Welcome to the NC DWI Guy Podcast, where defenders of the Constitution assemble to prepare for courtroom battle and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the NC DWI Guy, Jake Minick.
Hello, fellow freedom fighters, and welcome to another episode of the NC DWI Guy Podcast. Today, we're talking about the walk and turn test. Walk and turn. This is something that is central to DWI defense because it's something that happens in nearly every DWI investigation, right? This is going to help in your consultation. This is going to help when you're evaluating an officer's DWI or written narrative. This is going to help when it comes to actually cross-examining an officer when it comes to walk and turn during trial. So this is the good stuff. This is central to DWI defense. Before we jump into today's topic, just want to offer a thought about how to prepare for trial. In any case that you have that is going towards trial, you should bounce your case off of another attorney. Always bounce your case off of another attorney. Two heads are better than one. Run your fact pattern by another attorney and see how they would handle the case. See what arguments they would make, what type of defenses they would bring up, what type of motions to suppress they would utilize. Get another person's thoughts. Get a second opinion. Whether you're asking somebody else in your own office or another attorney that's in the local bar, other attorneys are ready, willing, and able to offer you a second set of thoughts about your particular client situation. So utilize that. Make sure that you take advantage of the bar association. We spent last podcast, episode 46, talking about the value of the criminal defense bar. Megan Burke really laid out well for us why that's important. So use the two heads are better than one approach. If you can't find anybody locally that you can talk to, then call me. I'd be happy to offer a second set of thoughts about your particular DWI case. We have offices throughout the state of North Carolina, in Asheville, in Charlotte, in Durham, in the Raleigh area, in Wilmington. So we very well may have an attorney that practices regularly in the county that you have a case in that could offer even more localized thoughts about your case. But I'm more than happy to talk to any attorney about their particular fact pattern, because this is how we get better as a defense bar. This is how we get better as a group to be able to bring the best arguments to bear. I always ask other attorneys' opinions, sometimes in the office, sometimes with local attorneys here in Asheville, but I always ask for second attorneys' opinions about how I should be handling my case. It doesn't matter if it's the first case that you're handling or the 1,000th case DWI trial that you're handling. Bounce it off of somebody else. So if you can't find somebody to talk to, give us a call. Be more than happy to talk to you about that. So today we are talking about the walk and turn test. This is one of the 3 standardized field sobriety tests. We have already talked about the other 2 in previous episodes. I'm sure that we will again talk about some of these in a different light in the future, but we talked about the horizontal gaze nystagmus test with Anthony Palacios on episode 20. We talked about the one-leg stand test just a couple of episodes back on episode number 45. So if you want to have the full battery of standardized field sobriety tests, then listen to episode 20 on HGN, episode 45 on one-leg stand, and today's episode 47, on the walk and turn test. In terms of Anthony, just to reference him, since he really crushed the horizontal gaze nystagmus evaluation on episode 20, he recently, at the end of 2020, started a online resource opportunity subscription package for attorneys on his website. So look up Anthony Palacios, and his company is Impaired Driving Specialists. Look up his company and subscribe to his podcasts, online training courses. His subscription fee is extremely reasonable, great value. I mean, this is the master of attacking how an officer does their evaluations, so does their field sobriety tests. He gives courses on the 24-hour NHTSA student course, A-RIDE, student DRE. He has all of the instructor manuals, gives training for the instructor DRE courses. So take advantage of that online subscription package. I am getting paid nothing to promote Anthony on this front. He doesn't even know that I'm doing this. So again, this is just a great resource. I signed up for it, as soon as Anthony let me know about it, and have been really impressed with the videos on there. So check that out as a great resource. So let's dive in to the walk and turn test. Obviously, this is something that officers are utilizing in nearly every DWI investigation. At least a NHTSA trained officer is utilizing this test very frequently, or should be very frequently utilizing when it comes to their own testing. So first thing that we need to know is what are the ways to attack the walk and turn test? What are the things that the officer should look for? Because ultimately what the officer is hoping to say is that I saw 2 or more out of the 8 clues on the walk and turn. Boom. That's the end of the analysis, right? That's the end of the analysis. It's not. It's not the end of the analysis. The officer has to do the test in the appropriate environment, in the appropriate testing conditions. So that's the first thing to look at. Was this done in the appropriate environment? Environment's number 1. Second, was this done on an appropriate subject? Was it done on the appropriate person, on the driver? Was this an appropriate person to test? So subject is number 2. Third, did the officer give the standardized instructions according to his training? Did he appropriately instruct on the test, on the walk and turn, and demonstrate the walk and turn to the extent that he's required to under NHTSA? So that's number 3. And then finally, number 4, did the officer actually appropriately notate clues that he is saying he observed, he or she is saying that they observed on the test? Were the clues that they indicate on the driving while impaired report or written narrative actually correctly indicated? So those are the things that we're going to be looking at today. First, it indicates this is, again, one of the 3 standardized field sobriety tests. It's also one of the 2 divided attention tests. So of the 3 standardized field sobriety tests, 2 are divided attention tests. The one leg stand, again, we talked about that episode 45, and the walk and turn. Those are the 2 divided attention tests of the 3 standardized field sobriety tests. Most of what I'm about to go over comes from the 2018 NHTSA student manual, right? 2018 NHTSA student manual. This is, as I've said in the past, the Bible for cross-examination on DWI cases. If you have not taken the 24-hour NHTSA course, sign up for that. If you don't have a student manual, get a copy. This is the framework for your cross-examination. So in session 8, kind of starting at page 62, we have the walk and turn test. So test conditions, environment, what does that look like? The manual says, whenever possible, the walk and turn test should be conducted on a reasonably dry, hard, level, non-slippery surface. Reasonably dry, hard, level, non-slippery surface. There should be sufficient room for subjects to complete 9 heel-to-toe steps. So you got to have the adequate space and you've got to have the adequate environment. So reasonably dry, hard, level, non-slippery surface. The manual indicates that recent field validation studies have indicated that varying environmental conditions have not affected a subject's ability to perform the test. So they reference that. But the manual then goes on to say, standardizing this test for every type of road condition is unrealistic. The original research study recommended this test be performed on a dry, hard, level, non-slippery surface and relatively safe conditions. If that's not present, the research recommends 1, the subject be asked to perform the test elsewhere, or 2, only the HGN be administered. So even though recent studies have said that environmental conditions have not impacted this, the original research and the language associated therein is still in the manual, still in the 2018 manual. And it says that if you do not have a relatively or reasonably dry, hard, level, non-slippery surface, that you can either A, find another place that does meet those conditions to perform the walk and turn test, or B, only do the HGN. We don't want to get false positives. We want to eliminate, or at least the NHTSA research wants to eliminate false positives that are caused by environmental conditions, caused by the roadside conditions. So either find a reasonably dry, hard, level, non-slippery surface to perform the walk and turn test on, or perform only the HGN. So how does this first environmental condition come into play when it comes to attacking a walk and turn test? Well, in a situation where you have a sloped environment, or where you have a soft environment, this is being done in grass or tall grass, you have a wet environment that this is being done on, in the rain, snow, whatever it might be, that is something that you should then bring to the officer's attention, and then point them to this section in the manual and say, this wasn't a reasonably dry, hard, level, non-slippery surface, was it? No, it wasn't. It was as good as I could find under the conditions. Fair enough, Mr. Officer, fair enough. This is as good as you could find. There wasn't any other location on scene that you found that was more dry, was harder, was more level, was less slippery. You didn't find any other place on scene that you could do that. Is that correct? No, I mean, this was as good as it was going to get. There wasn't another place to do it. We were outside. This was the environment that the stop occurred in. All right, fair enough, Mr. Officer. Now, in your manual, you're aware that if you cannot find a reasonably dry, hard, level, non-slippery surface, that you should only perform the HGN. Is that right? Point them to the manual. May I approach, Your Honor? Point them to the manual. Research recommends subject be asked to perform the test elsewhere, or only the HGN be administered. Correct. That's right. Yeah. Only probably according to the manual, it says that only HGN should have been administered. But I was trying to give your client the benefit of the doubt. I wanted to give them the ability to do tests. That is a cop out. They're not trying to give your client the benefit of the doubt, right? If this is not being done in fair testing conditions, then that's not giving the person the benefit of the doubt. Giving the person the benefit of the doubt would be to say, I did give them the walk and turn test, and then I didn't really take into account any of those clues or use those in my arrest decision because this was not a reasonably dry, hard, level, non-slippery surface. So I didn't really take into account those clues. No, they're going to take those clues into account and use those as the basis for their probable cause to arrest. So point them to this section in the manual and say, you're either supposed to ask the person to perform these in an appropriate environment, or only do the HGN. Once you get the officer to walk through that, at the point that you have the opportunity to give a closing argument, you make sure that you tell the judge on PC or the judge or jury in closing at trial, you can't use the walk and turn, judge. You can't use it in any way, shape, or form because the officer admitted that his own training said that under these testing conditions, under this environment, that only the HGN should have been done. That's it. That's all I'm saying, Judge. The HGN is the only thing that should have been done. I'm not arguing that the officer had a place to do these tests, the walk and turn and the one leg stand. I'm not arguing that there was a good place or a better place to do those. I'm saying that because of the environment they were done in, Judge, you can't consider him at all because his own training says that the only thing that he should have done was HGN. So if you have a case where you've got a officer that sees 4 out of 6 on HGN, 3 out of 8 on the walk and turn, 2 out of 4 on the one leg stand, but it's not done in the appropriate environment, you tell the judge, can't consider walk and turn and one leg stand. Yeah, you can still consider the HGN, but that's it. It wasn't done in an appropriate environment. And the officer's training says the only test that should have been administered was HGN. So just ignore the fact that you've heard that and maybe specifically file a motion to suppress the walk and turn and the one leg stand themselves based on the environment as part of your suppression motion or prior to trial. So that is environment. Number 2, we look at the subject. Sorry, what does the NHTSA manual say about the subject? It says that the original study suggested that individuals over 65 years of age or with back, leg, or inner ear problems have difficulty performing the test. Also, the study suggests that individuals wearing heels more than 2 inches high should be given the opportunity to remove their shoes. Officers should consider all factors when it comes to conducting SFSTs. So that's straight from the manual, right? Straight from the manual. Original research shows over the age of 65, back, leg, or inner ear, take the shoes off. So if you have a client that is 65 plus or has back, leg, or inner ear problems, then make note of that. As we noted in the one leg stand discussion in episode 45, there is an additional issue for one leg stand, and that is being 50 pounds or more overweight. The overweight issue is not noted for the walk and turn test. So weight is not a concern factor in terms of the subject being able to perform the test when it comes to walk and turn. But age is still a concern, 65 plus. Medical background, back, leg, or inner ear problems is still a concern. And the opportunity to remove a 2-inch plus heel. All of those are factors. Now, how does this play out? A lot of times what you'll see somebody, an officer say is, do you have any back, leg, or inner ear problems? Yes, I do. I tore my ACL and MCL a couple years back. I have had difficulty with walking, somewhat since that time. It bothers me from time to time. Okay. So what would you think then the appropriate response to that would be? The appropriate response would be, okay, that seems to qualify as a leg problem that would give somebody difficulty performing the test. But what happens in every single situation that you see? The officer then says, well, is that going to impact your ability to perform this test? Do you feel like you could walk down a straight line? No. When you're told that, when you're given that information at the roadside that the person has back, leg, or inner ear problems that would likely cause difficulty with the test, you just say as an officer, probably not appropriate. But again, we always hear the officer say, well, I was trying to give your client the benefit of the doubt, and so I wanted to make sure that they went ahead and had the opportunity to perform every test to show me that they were sober. No. This is the ability to show a person false positives due to difficulty with leg, back, or inner ear. So again, when the officer says that, when that's in the report, when that's on the video, your client, right when they ask about that medical issue, says, do you have any back, leg, or inner ear problems? Make sure you bring that up and say, he said that he did, Judge. And yet the officer is still sitting here despite the research, despite him being told that my client had, he's still sitting here saying, I saw 4 out of 8 clues, and the prosecution is over here saying that shows impairment. They're still using those 4 clues that they shouldn't use. What's the point in having this medical check off for the walk and turn if we just kind of ignore it. And we ignore it because the officer kind of follows up and says, well, do you think you can still walk even though you have your ACL? Yeah, they can still walk, but that's a problem. It's going to create difficulty performing a walk and turn test where balance is in question, where you're not used to walking in a specific way. It's just common sense that that's going to cause a problem. And so to then ask for the judge to consider 4 out of 8 on the walk and turn where somebody does have knee issues, leg issues, back issues, that's not fair. I mean, it's just at the end of the day, not fair. So don't let them get away with that. Don't let them just kind of brush that past and say, well, the person said they could still walk. That's not what the question is. That's not what the research concentrates on. Also, if you have a case where the officer does not ask about medical issues, does not have any type of medical questionnaire, bring that out. If it's on video that he goes straight from HGN and says, okay, I'm going to have you perform another test. Come over here. I'm going to have you imagine a line right here. However they transition to walk and turn, don't let them just sit there and kind of say, didn't appear to me that there was any, back, leg, or inner ear problems. They're supposed to ask about that. They're supposed to see if there is any issues performing the test. So again, if there wasn't a appropriate question done, that should come into play in assessing the admissibility and the value, the evidentiary value of the walk and turn. So for the walk and turn test, we have 2 stages. We have the instruction stage and we have the walking stage. For the instruction stage, there are 2 clues. For the walking stage, there are 6 clues. So when it comes to the administrative standardized procedures for the instruction stage, this is what the officer is supposed to do. He's supposed to give these verbal instructions accompanied by demonstrations of the test. So he's supposed to say, place your left foot on the line, real or imaginary, right? So whether he's using a real or imaginary, and the training protocol says that you can use either a real or an imaginary line. So it tells the driver, place your left foot on the line, real or imaginary. Place your right foot on the line ahead of your left foot with the heel of your right foot against the toe of your left foot. Place your arms down by your sides. Maintain this position until I have completed the instructions. Do not start to walk until told to do so. Do you understand the instructions so far? Very clear, right? Very, very clear. Put your left foot on a real or imaginary line. Place your right foot in front of your left with the heel of your right foot against the toe of your left foot. Place your arms down by your sides. Maintain this position until I tell you to begin the test. Do you understand? That's it. Okay. Very simple. So that is then putting the suspect into the starting position. He then is going to give a further explanation of what he wants to see during the test, as well as a demonstration. So the manual says, explain the test requirements by giving instructions accompanied by demonstrations. When I tell you to start, take 9 heel-to-toe steps on the line, turn, and take 9 heel-to-toe steps down the line. When you turn, keep the front lead foot on the line and turn by taking a series of small steps with the other foot like this. So he's going to demonstrate 3 steps. He's going to demonstrate the turn, and then he's going to demonstrate 3 of the 9 steps back up the line. While you are walking, keep your arms at your sides, watch your feet at all times, and count your steps out loud. Once you start walking, don't stop until you have completed the test. All of these are very important instructions and demonstrations, showing how you want the suspect to walk, showing how you want the turn to be made, showing how you want the arms to be, showing that you want the person to keep walking until they have completed the test are all very important instructions. And then finally, the officer says, do you understand the instructions? Then instruct the person to begin the test. So the officer is going to show starting position during his instructions. He's going to demonstrate 3 steps down the line, demonstrate the turn, demonstrate how the person is supposed to hold their arms, demonstrate how the person is supposed to count, and indicate to the person not to stop walking once they have begun the test until they have completed it. All right. So now we're looking at the test clues, the test interpretation. So again, there's 2 clues that the officer can notate during the instruction stage and 6 during the walking stage. Before I guess I move on. So again, number 3 of our issues is looking at, did the officer appropriately instruct the person? The only way to really get the answer to this is to get video. You can't really tell whether or not the officer appropriately instructed your client without the video, but the video is incredibly powerful. A couple of examples of this. If on the video, the officer never says, don't stop walking once you have begun the test until I tell you, until you have completed the test, he omits that instruction. Your client stops walking several times during the test. That should not then be marked as a clue because the person was never told that they could not stop walking. Okay, so that eliminates that clue, or at least it should eliminate that clue. If the officer incorrectly demonstrates the test, then that is going to be a problem. That's a problem. Don't let that go unnoticed. If the officer turns the wrong direction at the end of the line, or doesn't make a series of small steps, doesn't appropriately demonstrate, nobody should know how to do that unless they are watching the officer do it. If the officer doesn't demonstrate the turn at all, then any notation about how the turn was supposed to be done versus how it was actually done should be eliminated, because it's not an easy or intuitive way in terms of turning. So that's why the demonstration is required as part of the standardized instructions and demonstrations. So look at the video to determine, did the officer give all the audio appropriate instructions, and did he give the visual appropriate demonstrations? Make sure that you see both of those things and notate whether or not they are there. All right, so test instructions. It says, the first clue, the first of the 2 instruction stage clues is that the suspect cannot keep balance while listening to instructions. 2 tasks are required at the beginning of the test. The subject must balance heel to toe on the line. At the same time, listen carefully to the instructions. Typically, the person who is impaired can only do one of these things. The subject may listen to the instructions but not keep balance. Record this clue if the subject does not maintain heel to toe position throughout the instructions. It then says the feet must actually break apart or step off the line. Now, here's a very important thing. It says, do not record this clue if the subject sways or uses arms to balance, but maintains heel to toe position. Interesting, right? So all it's going to say on the DWIR is the person did not maintain balance during the instructions. Well, you might think that somebody that is swaying back and forth or having to use their arms for balance despite being told to keep their arms down by their sides isn't maintaining balance. But if you watch the video and your client never moves their feet, they can be literally doing like a hulu dance. I mean, they could be doing anything in terms of how they are moving, using their arms for balance. They can look like a wild person, but as long as their feet stay planted, that then is not an appropriate recording. It says, do not record this clue if the subject sways or uses arms for balance, but maintains heel to toe position. So again, the clue on the report says cannot maintain balance during instruction stage. What that really means is feet broke apart. That's what it means. So know that that's what the officer is supposed to look for, and check that that's what happened on the video where possible. The second instruction stage is that the person starts the test too soon. So the impaired person may be able to keep balance but not listen to the instructions. since you specifically instructed the subject not to start walking until I tell you to begin, record this clue if the subject does not wait. So if the person starts the test before they're instructed to do so, the officer is supposed to record that clue. However, note the way that the instructions are supposed to be given. The first thing that the officer tells during the instructions is place your left foot on the line. Then he says place your right foot in front of the line. Place your right foot on the line ahead of your left with the heel of your right foot against the toe of your left. Place your arms down by your sides. Maintain this position until I have completed instructions. So that's the first time. At the end of those kind of first set of instructions, at the very end is when he says, maintain this position and don't start the test until I tell you to begin. He says, maintain this position until I've completed my instructions. Do not start to walk until told to do so. If your client starts walking before they're told to do so, but the officer hasn't given that instruction yet, that's not a clue. That's not a clue. This is a clue if the officer has said verbally, don't begin the test until I tell you to start. And then they start walking. But if they get set up in the starting position and start walking, and then the officer says, no, I don't want you to start yet. Get back into the starting position. That's not starting walking too soon because they've not yet been told by the officer not to begin walking. This clue should only be notated if the officer has already instructed the person to not begin walking and yet they do it anyways. That's what the clue is for. It's not anytime the person starts walking down the line without being told to. It's only if the officer has previously told them, don't start the test until I tell you to begin. So those are the two instruction phase clues. Now for the 6 walking clues. So it says, first walking clue, stops while walking. This says the subject stops while walking. It says, do not record this clue if the subject is merely walking slowly. So slow walk is not the same as no walk. Slow walk is not the same as no walk. Also, you can't record this clue if you've not told the person that they should continue walking until they have completed the test. So if the officer doesn't say that, then you can't record the clue. Second clue, does not touch heel to toe. The subject leaves a space of 1/2 inch or more between the heel and the toe on any step. So there is your specific distance required. 1/2 inch between the heel and the toe of any step. That's not very much. That's not a lot of a distance. So it's a pretty small distance. But again, if you have an officer that doesn't realize that any distance, that says any distance that is required, he will note the clue, then you might be able to use that in terms of cross-examination. Clue number 3 on the walking portion. So this is really 5 out of 8. Steps off the line. Subject steps off the line. The subject steps so that one foot is entirely off the line. That sounds pretty straightforward, right? But if you kind of reverse that, don't mark this clue if any portion of the foot is still on the line. What the manual says is that the subject steps so that one foot is entirely off the line. So if one part of the heel, one part of the toe, one part of the shoe is still on the line, even only by a sliver, this clue is not an appropriate clue. Can't note it if there's any portion of the foot on the line. Also, when it comes to an imaginary line, if the officer is not using a real line, this seems to be utterly ridiculous in terms of noting this clue when somebody is stepping entirely off of an imaginary line. It's impossible to really step off entirely an imaginary line unless you are, putting a foot out to the side. I mean, how could you possibly say the person stepped off of the imaginary line? So this is, again, maybe there are no real lines to use. That's going to be pretty rare, but maybe there are no real lines to use. Don't let the officer get away with marking this clue when it comes to an imaginary line. Number 4 of the walking stage clues is uses arms for balance. So it says the subject raises one or both arms 6 or more inches from the sides in order to maintain balance. So unlike the one leg stand test where it says raises both arms, the walk and turn says raises one or both arms 6 or more inches from the sides in order to maintain balance. Okay. So it could be either arm has to be 6 inches or more from the sides. Improper turn is the 5th walking stage clue, or the 7th clue overall. Improper turn. The subject removes the front foot from the line while turning. Also record this clue if the subject has not followed directions as instructed, spins or pivots around, or loses balance while turning. We have one judge in Buncombe County that I think is really taken probably the correct approach to this particular situation. He said several times that, does anybody make the turn appropriately? You know, basically every walk and turn test that I hear, the person has made the turn inappropriately, has been noted for the clue of improper turn. And that's because this turn is the most ridiculous movement when it comes to any field sobriety test. It's just an utterly ridiculous movement. But again, in terms of attacking the clue, did the officer appropriately give instructions and demonstration when it came to how to perform the turn? Make sure that the appropriate instructions and demonstration were given. And then the final clue, so the 6th walking stage clue and the 8th clue overall, is that the person took the incorrect number of steps. It says record this clue if the subject takes more or fewer than 9 steps in either direction. Now, one of the instructions tells the person to begin counting on their first step. So if, again, that is changed or omitted or not clear, then make that argument. Say that the officer, if the officer says, well, he only took 8 steps down and 9 steps back because he didn't count his first step. If the instructions weren't clear, that's on the state. That's on the officer. Don't let them get away with that. If the person takes the incorrect number of steps down and then turns the opposite direction of how they were supposed to turn, the turn itself should not be marked as inappropriate because that's based on the steps itself. You can't double punish somebody for that. If they still are taking the series of small steps and turning around, even though now they're turning left versus turning right, turning right versus turning left, then that doesn't count if that's based on the steps. So make sure that you have all of those clues and indicators. At the end of the walk and turn test, it says SFSTs are a tool to assist you in seeing visible signs of impairment and are not a pass or fail test. They're not a pass or fail test. So use those means of attacking the walk and turn. Now, ultimately, if somebody shows the 2 or more clues, so if the officer sees 2 or more clues, then the research indicates that there is a 79% chance that the person has a BAC of 0.08 or greater. Okay? Walk and turn test, 2 or more clues indicates a BAC at or above 0.08. Okay? Now, if you have a situation where you cannot argue that this was done in an inappropriate environment or on an inappropriate subject, or that the officer didn't give the correct demonstrations and instruction, or you cannot actually attack the results of any of the notated clues, and the officer indicates that 2 or more clues are present. You can't attack any of those things that we've just gone through, 1, 2, 3, or 4. Environment, the subject that it was done on, the officer's demonstrations and instruction or the clues themselves that he's notating, if you can't attack those things, you still may have an out. You still may have a saving grace. And that is, and I see this routinely in district court, where the district attorney does not connect the results of what is being seen from the tests to any kind of meaningful arrest decision. Okay. So if the officer says, I saw 4 out of 8 clues on the walk and turn test, and that ends the discussion, it ends the direct examination by the state of the officer, and then they move on to the one-leg stand or move on to the PBT or move on to the next part of the test, the officer hasn't given any meaningful way for the judge to evaluate what 4 out of 8 clues mean. Now, of course, we know judges hear HGN, walk and turn, one-leg stand every day until they are sick of this stuff, right? They hear it every day. So they know what 4 out of 8 clues means. They know what 2 out of 4 on the one-leg stand means. They know what, 6 out of 6 on HGN means. They know what these things are. And they know that 4 out of 6 required for HGN, 2 out of 8 on the walk and turn, 2 out of 4 on the one-leg stand. But when we have a district court trial, we are operating in isolation from all of other evidence. As the superior court judge says to the jury, you may not consider evidence that is outside of the record, stuff that you have personal knowledge, past experience with. You are to come in with a blank slate, and whatever is said on the witness stand, whatever exhibits are presented, that's the evidence. So if the state doesn't ask questions of the officer, and it's a simple question really, when you say that you saw 4 out of 8 clues with Mr. Smith, what does that tell you? The officer can simply say, that gives me a probability that the person was impaired. Boom, they've made the connection, right? Or they could even be more specific. That gives me a 79% indication that the person was impaired or had a BAC of 0.08 or greater. Boom, there's their connection. But if they don't make that connection, if they just say, how many clues did you observe with Mr. Smith? 4 out of 8. Okay, thank you, officer. Let's move on to the one-leg stand test. If that's how the state does it, they have not given any reasonable way for the judge to evaluate the clues that were seen on the walk and turn. Don't let them get away with that. That's just not enough. It's not enough. So make sure that you argue that in your closing. Make sure you argue that in your closing. So when it comes to the walk and turn, know those 4 things. Know the environment and the conditions that are required to do the test. Know who the test is appropriate to be done on, what the subject has to bring, age requirements, medical conditions that could cause problems. Know what the appropriate suspect is. Know the instructions and demonstrations that the officer is supposed to give. And then finally, make sure that you know what the clues are that the officer is looking for, and see if there's a way to attack whether those have come into play. Hope this has been helpful, and I look forward to speaking with you again next time. Hope you enjoyed today's episode of the podcast. If you did, please share the podcast with another freedom fighter in the criminal defense community, and be sure to leave us a rating on iTunes. See you next time.